Hi. Welcome back. Welcome back. Hopefully we had a nice long weekend. You all forgot where you sit, but hopefully you all recall now. So first of all, I got to make an announcement. So I mentioned last class that all my old classes are recorded, and that I encourage you to watch the old lectures before you come to class. So I forgot or got lazy, I'm not sure which one. And so a student said, "Where are our cookies?" So I went and I bought cookies. I got them for you also. So you are benefiting from their vigilance. You all did not notice that I forgot to bring them because you perhaps didn't watch my videos. But I started this tradition. My first day of teaching was actually my birthday, my first day ever teaching. And I thought it'd be a nice idea to celebrate it. I figured you would hate me enough already, so I might as well butter you all with cookies. So there are about 100 cookies here, which is more than enough for everyone. Enjoy them, pass them around. Also, here's this is much less fun with the dependency design as well. So, all right. Now that we got that out of the way, any questions? Sit down, sit down, sit down. Any questions from our class last week? What do you mean, any questions? Of course you have questions. I didn't take any time for questions. I appreciate that you gave me the opportunity to run through that entire class. Most law students will never read the entire Constitution. They won't. And in fact, until the 1980s, this may be shocking to you, most law school textbooks did not even include the Constitution inside of it. One professor in particular, whose name you may know, Lawrence Tribe, whose name was bandied about at the last presidential debate, his common law textbook was the #1 textbooks in the country. He did not include the Constitution in his constitutional law textbook until Attorney General at me said, "Hey, this is wrong." And now they put it as an appendix at the end. I put it up front. So with that, also one other note on the debate. So those of you who actually watched the Republican debate on Thursday, did anyone make note when Governor Christie said the Second Amendment was second because it was most important? Did anyone notice that? Did anyone say no? A couple of you emailed about this, right? So as you know, what we know is the right to bear arms was actually the fourth proposed amendment, not the second. So you learned something that a former U.S. attorney and governor did not know. So you're already well ahead of the curve, or Christie's curve, as it were. I'd like now to, a couple of you got that one. So I'd like now to do what I would usually do in the first day, which is to walk you through the syllabus and explain the outline of the class. Again, first class, I cannot do that, not enough time. So the course itself covers a lot of material. At most law schools, common law is a 6-credit class. You have 3 and 3. Unfortunately, we only have 4. It is not nearly enough time. There is a lot more common law than there is property, torts, or contracts, yet we only have 4 credits, such as life. So in this class, we will move very quickly. The readings will be heavier than your other classes, and I make no apologies for that, but you will need to follow along. In terms of the exam, as usual, we're going to have one final exam. It's completely and entirely open book. You can bring whatever you want. It will not help you. Notes will not help you. Commercial outlines will not help you. Horn books will not help you. If you want to know why they won't help you, look at my old exams. I've posted every exam I've ever given and the A+ answer. So there should be no surprises about what I expect. I am fairly predictable. I write the same sorts of things every single year. We will also have a midterm exam. Now, this is actually a little bit new. In the last year or so, the school's been putting gentle pressure on the professors to give midterms early in the semester to provide you feedback prior to your final exam. When I went to law school, I never had a midterm. You had the final exam, and that was your grade. And for a lot of people, that's like, oh my God, what just happened? I got a D, right? Where'd that come from? So the goal of the midterm is to give you an assessment early in the semester to perhaps correct your trajectory. Now, I did this for the first time last semester, and I found, with very few exceptions, the grade on the midterm became the grade on the final, plus or minus a third. So there wasn't much improvement. And that teaches me one of two things, right? First, people didn't take the midterm seriously. They told me, well, it was too early in the semester. We didn't have time to outline yet. Okay, I understand that. The second is people became complacent and said, well, if I did okay in the midterm, I'll do well in the final. And they more or less carried through. So I'm trying this semester a little bit different. Is I'm giving the midterm fairly early. I think it's at class 9 or 10. I can't remember the dates. It's February. You can look it up on the, hold on, it's right here. It's on February, I missed it, midterm. February 16th. So it's basically class 10. And I want to explain why I'm doing it that way. I'm not expecting you to actually make your outline by February or March. That was perhaps naive of me, and the students rudely told me we're not going to do it. So I expect nothing more of you. I'm not interested in testing you on a large body of knowledge. In fact, I want to test you on a smaller body of knowledge to see how you think. So there'll be less stuff for you to study. So hopefully you'll have more time to actually analyze the material rather than dumping through 20 classes and then moving it. The other benefit of giving the midterm early is I can turn them around and grade them quickly enough. Last year I graded them in about 2 weeks, but that semester I had about 100 students. This semester I have about 170 students. So it's almost double the size of the class. So I'll try and turn these around as quickly as I can so that you have feedback. So in terms of grading, now this is something which I'm not entirely crazy about. We are not allowed under our grading policy to include your midterm grade in your final score. We can't. Under our grading policy, which will probably be changed in the near future, your final score is based on a single exam. What I can do, and this is allowed, is adjust your participation score. So if you fail the midterm, you'll be bumped down by a third. So if you had a B, go to a B minus. It's not a harsh incentive. In fact, for most people, it's not an incentive at all. But it's at least something to make sure you show up and take this seriously. A number of people did very poorly on the midterm last semester, and unsurprisingly, they did poorly in the final. So this is your way of showing that you actually care about this class to do well in the midterm. And also, if you don't do well in the midterm, you'll be required to come meet with me. I want to talk with you, see what you're doing wrong. If you come and say, I'm doing the readings, I'm really, I'm trying hard, I'm struggling, I'll work with you. If you come and say, yeah, I didn't study, well, I can't do much to help you. And several people are honest, said, you know what, I didn't study. Okay, that's your call. I can't help you with that. So that's for the exam. Now, in terms of the scheduling for class, I'm perhaps unique among professors, but I value this very highly, is I stay on schedule. I've never once fallen behind schedule. If I say in a given class day we will cover these pages, we will cover those pages. We won't go beyond those. We won't go short of those. We'll cover what I say we're going to cover. So the flip side of that is you need to be prepared. You need to be prepared every class. This is not read 20 pages ahead. You know to the period what I'll be covering in any given day, so there's no excuse not to be prepared. The way I do recitation, or as you call it, class participation, is I move around the class. Everyone's on call. So for example, I'll start with this guy over here. I'll move up and down the rows, to the back, to the front, snaking around all the way. And each person gets one question, or two questions if I'm not so inclined. And the purpose of this form of participation is to make sure that you're always paying attention. Okay? I don't call on show of hands because that's not whatever. And I don't like the random name generator because it's already jumping around. I want this class to be a conversation. So if you say something, the follow-up to this guy. And if you say something, the follow-up to you, and to you, and to you. You need to know what your neighbor said. So if you're, in the middle of a row and I call on the person to your left, you're up next, you better start paying attention quickly. If I call on you and you're not prepared, I am not going to yell at you. I'm not going to scream at you. I'll just come back to you when I want to. At a point where it will not have been necessary for you to do the reading to answer the question. It'll be a question based on the class discussion. And if you don't answer that question, I'll come back to you another time when you're not expecting it. So please be prepared. I'm not going to be jotting down all this information. I don't, take notes on your participation, but I do usually keep a mental note of people who don't prepare. And unsurprisingly, at the end of the semester, the people who are least able to answer questions usually do the worst in the exam. It's almost without fail. So basically every single class has the readings laid out, Some of the readings will be from the book. Occasionally, I'll read something outside of the book. And by the way, the bookstore has everyone's book. Does anyone not have a book? Okay. Can you read from someone else? Did you read from someone else?
Yeah.
Okay, good. Yeah, the bookstore was short, but I think they have them all now. So all of the readings are here. There's no surprises. Okay. We're not going to be using Stanley. We'll be using the class blog. So if you ever have a question, you go to my blog, joshblackman.com. There's a link for classes. You click classes. Then there'll be a link for constitutional law, spring 2016, over here. If you click that. Visit that every day before class. You can do it in days we don't have class, I don't care. But every day before class, please, please visit that. Okay. On this page, there's a link to the syllabus up there. We have a series of posts. Every day, I'll have a post for class. So this is today's class, Common Law Class 2. So I have it over here. I'll always have projected on the screen two things. So here's today's posts. And it's hard to read, but you can see on your screen, it says lecture notes. If you click here, this pane will appear. Okay. These are notes that I type in class for you. And I often will type these, you know, in real time. I don't use PowerPoint. The purpose of these notes is to highlight certain provisions of text that I want you to focus on. These are not a substitute for your class notes in any way. These are things for you to follow along. That way, you don't have to ferociously type down what I'm saying. You can copy and paste it. If you have a computer, and if you don't have a computer, they're available after class. You can check them online. A lot of students would actually print these out, put them in a binder, and bring them to the final exam as their own outline pack. Do whatever you want. I don't care. All right? But the issue here, is I want you to be involved. We also have on every single post lots of pictures. I love pictures. I'm a visual learner. I suspect many of you are. So I have lots of graphics to illustrate these cases. And at bottom, all of constitutional law is X versus Y. X and Y are people. They're people with problems of some national import, which is why the Supreme Court of the United States resolved it. Okay? So questions on the format of the class? Yes, sir.
So, you post the videos before the lecture or after?
Well, I can't post things that haven't happened yet. I haven't figured that quite yet. But all my lectures from last year are available. So if you go to the syllabus, right, I'll go back to the syllabus. On the syllabus, there'll be a link to a YouTube channel from last year. It's, I'll find it for you. Okay, so here it says Constitutional Law Lectures from Fall 2015. See that? If you click that link, YouTube will pop up. And I look more or less the same. I may have been wearing the same tie. I'm not sure. Well, I think I match. Okay, I don't have that many shirts. Oh, they're all white. So if you scroll back here, you'll see all my old lectures. So class 1, class 2, you know, and you could see how I began class last year and what I said and whether or not I gave out cookies. Different time.
Hi, everyone.
Anyway, so there's that. It's weird watching yourself, but I often do it to make sure I taught things correctly. I often go back and I watch, make sure I did things right. Don't always do it. Usually I try. Okay. Any other questions in the syllabus? And again, the important point is you're on call every day. Be prepared. The readings are heavy. It's also a 4-credit class instead of usual 3. You'll occasionally have 30 to 40, sometimes even 50 pages of reading. So budget accordingly. Especially at the end of the semester, people always trail off. And I make note to always test stuff at the end of the semester. For example, the last couple of days of class are the First Amendment. And by then, people usually tune out. And if you look at my exams, I ask for the First Amendment every year. And every year, people screw it up. So stretch out it's endurance, it's a marathon, okay? All right. Any other questions? Okay. So today's class is going to challenge a lot of the conceptions that you may have been taught about the courts, especially in your first semester of law school, where you've simply taken for granted that when a court says jump, people say how high. That does not need to be the rule. So is that, I'll just start with Tariq. Tariq, let me ask you a question. Why do people obey courts?
First, you have to.
Whoa, we may have to. Why do people obey courts?
The Constitution has to be.
So what? Why do people follow the Constitution?
Without the alternative, not for the Constitution.
So what's your name? Jacob, is there anything in the Constitution that says people have to follow the courts?
Yes, sir.
What?
It says that actually, I don't know who said.
Oh, well, what were we going to say? You're going to say something. I think I know what you're going to say.
I was going to mention the Supreme Court.
Okay, so this is the Supreme Court. Does it say anywhere in the Constitution people have to obey the Supreme Court?
It says there is supreme law for me.
Oh, the Supremacy Clause. Good. So you were paying attention to class last week, right? So let's read it, okay? Article 4. The Constitution and the laws of the United States, which we have made in pursuance thereof, and all treaties, shall be the supreme law of the land. Jacob, what is the supreme law of the land?
Constitution and the law of the United States.
Does it say anything about the Supreme Court there? Oh, so now what's your name? Catherine, let me ask you the same question. So why do people obey courts?
I guess for generation, the obligation.
What do you mean obligation? What does that mean? You're re-saying my question. Why do people have this obligation?
Because they have declared themselves as the supreme.
Well, good for them, but why do people listen? I can say I'm the queen, right? I'm the king, but he wants to listen to me. Why? And what's your name? Oh, great. Really? Actually, that's easy. Catherine, what, last initials, Catherine D and Catherine E. You're in alphabetical order too. Wow. So, perfect. Spelled the same way. Wow, Catherine. Okay, so Catherine E. Why do people obey courts?
Well, because
Why do people listen when a judge says something? Why? Well, let me ask you a different question, Catherine. Let's say Catherine and Catherine sue each other. Catherine v. Catherine, right? And Catherine, the breach of contract, and this Catherine gets a judgment against you, and the judge says you're required to pay this Catherine, $1 million, and you say screw it, I'm not doing it. What happens?
the court would, I guess, ask another branch to help them.
Oh, so if you tell the court judge screw it, I'm not going to pay her, what's the court going to do?
They could get the sheriff.
Sheriff. And what's the sheriff going to do?
I'll execute
They'll take your property to satisfy the debt, right? Who's at the end? Is that Zach?
Yes, sir.
Zach, can a court by itself do anything? That is Catherine v. Catherine, this lawsuit, right? The court said Catherine has to pay Catherine $1 million. Catherine says no. Can the court do anything about it by itself?
Yes.
What can it do? Bang her in the head with a gavel? I mean, what can the court do?
I guess like what she said, I guess get warrants or take your property or so on. So
But who's taking the property? Who's seizing the assets?
the government.
Okay. Which branch of government? We're in law school here, not just government. There's not some monolithic entity. Which branch of government?
So the legislature.
Who's your sheriff work for?
State.
The sheriff, the sheriff make laws. What is it? What are the three branches of government?
Judicial, executive, and legislative.
So we have three branches of government, right? Montesquieu and others have written about this for centuries. We have the executive, legislative, and the judicial. All right? Is that Shelby in the back? Shelby, what are the roles of the legislative branch? The legislative branch, please.
Oh, they make the law.
What does that mean, they make the laws?
I guess they come up with the different laws that we're supposed to abide by.
Okay, so the legislative branch enacts laws. Now, this could be the United States Congress, the Texas State Legislature in Austin, even the Houston City Council, right? Every level of government has the ability to make their own laws. Okay. Oh, before I forget, I want to make an announcement. So, are you in the Federal Society? So, want to make the announcement? Do you know about the event on Thursday? I'll do it. Sorry, I meant to call you up. So on Thursday, there's a student organization called the Federal Society. Figures I'm mentioning it now. It's a conservative libertarian organization, but they bring in speakers from out of town. And on Thursday at 11, which I know you don't have class, so right before this, Thursday 11, my common law professor, David Bernstein from George Mason, is coming. And he's giving a talk on a book he wrote about the executive power. He's going to be discussing a lot of themes we'll talk about in this class. So I strongly recommend you come Thursday. I'm going to put an announcement. It's Thursday at 11. I'll be there, and David's a dear friend of mine. And if that was enough of an incentive, there's going to be Jimmy John's. So people don't care much about substance, but there's free sandwiches. So the details are up here. 1 second. I'll put them up here 1 second. Sorry, I just remembered because I know I don't see you till noon on Thursday. So if I tell you after, it'll be too late. Okay. Okay. Details here. So there we go. Anyway, so it'll be Thursday at 11. I'll be there. I strongly encourage you to go, and there'll be free Jimmy John's. Okay. So going back to the question, right? The three branches of government. We have the legislative branch, Shelby correctly said. The legislative branch makes the laws. Okay. Cindy, what does the executive branch do? What do you mean enforce them? What does it mean to enforce the law? Yeah. Police officers, sheriffs, right? This is the question we mentioned before. Say the legislature passes a law. Let's call it the UCC. Okay, someone breaches a contract under the UCC. There are damages. Someone doesn't pay the damages. You call the sheriff and you seize their property. Now, when you study contracts, you ever think about what happens after the judgment, right? All you say is like, judgment affirmed, the judgment reversed. You don't care what happens after. After it, that's where society kicks in. The legislature enacted the UCC. Person doesn't pay up. You send the police in, send the sheriff to seize their assets. Now, is that Natalie? Natalie, so then what's the role of the judiciary? What is the role of the judiciary?
I believe their role is to sort of take the laws that the legislative branch enacts and interpret them.
What does that mean to interpret them?
Well, to assess whether or not they're applicable in situations.
Assess whether or not they're what?
The laws are applicable.
Applicable. What does that mean, applicable?
Whether that law can be used to assess whether the person on trial has in fact broken that law.
Okay, so let's take an easy example. Catherine v. Catherine, right? Catherine squared. One sues the other. Too easy. One sues the other for breach of contract. And in that state, you have the UCC, right? You have the standard, restatement, second of contracts, whatever it is. Catherine says, we had a contract for widgets and she breached it. And then the other Catherine says, no, I was under duress. The contract is not void. Standard, easy contract case. What's a judge to do there? Natalie?
Well, the judge's job, I suppose, in that situation would be to assess
Good.
the law, the written law, the law that is in place, the law, and to determine based on the actions of the actors.
Well done. Right. So, actually, I didn't make that up. We actually have a case later this semester called Rosengrant v. Rosengrant. They're a married couple who sue each other. So I've done the square joke before, but not with students. So you're right. Courts look at the law, they look at the parties, they look at their arguments, and make a decision. But after the court makes its decision, hopefully Catherine number 2 pays up. And if she doesn't pay up, the court sends a warrant to the sheriff and says to the sheriff, go seize her assets, collect her home, collect her money to pay up the debt. Okay, now everything usually works out just fine. Is that Whitney? Whitney, tell me, what happens if the judge tells the sheriff, go seize Catherine's property, and the judge says, no, I don't agree with your ruling. She was under duress. There was no breach. The sheriff says, you know what? Duress, there's no breach of contract. I'm not seizing her assets. Your ruling's wrong. No, don't fight the hypo. I'm telling you, the judge tells the sheriff, go seize her assets. And the sheriff says, you know what? I think she was under duress. There was no breach of contract. No contract was ever formed. I won't seize the assets. Judge, you're wrong. I'm sorry?
I wouldn't think it would matter what the sheriff thought.
Why not? Why not? Says who? Says who? A few minutes ago, one of your colleagues said the Supremacy Clause says that the Supreme Court's the law of the land. Who's supreme, Whitney? By the law. The law is what's supreme, not judges. The law. Read it. It's right there. I'm not making this up. Read it. The law, the Constitution is what's supreme. And the judges are bound by that law. Now, I don't need to be picking on Whitney, but she said was probably what most people think. Who the hell is a sheriff to say what the Constitution means, right? Who the hell is he? Do you know law school? He doesn't know what I know. There is nothing in our Constitution, nothing, which says that the court has the final word on cases. In fact, that rule only came from the court itself. In 2 decisions I asked you to read for today was Marbury and Cooper v. Aaron. But the Constitution is silent. I mean, maybe it's right, maybe it's wrong, but the Constitution itself is silent. So I gave you a hypothetical, right? A fairly easy one about what happens if, the sheriff decides not to agree with a court order on a breach of contract case. And I may say, all right, Josh, that's stupid, right? Who cares, right? Who cares if a judge says, about the breach of contract? But we've had experiences in our republic where the executive branch or the states did not agree with judgments of the Supreme Court, and they opted to ignore them. So one of the first examples I'll mention is the decision of Dred Scott. We'll discuss Dred Scott in much more detail later in the semester. But to cut to the chase, Chief Justice Taney in that decision held that Africans were not people. They could not be citizens under any circumstances, even if they were freed. And slavery was, in fact, a constitutional right. Summarizing a very long decision in 2 sentences, that's the gist of it. Abraham Lincoln, who at the time was running for president, said the Supreme Court is wrong. 5 justices of the Supreme Court do not make the law. I disagree with this decision. In fact, Abraham Lincoln likely won the presidency on the platform of saying that the Dred Scott decision was illegitimate, that it was wrong. We went to a civil war, a bloody civil war over the Dred Scott. Most oversimplifying, but it's not much of a stretch that Dred Scott spurred the Civil War. We'll talk about this much more later. Here you have Abraham Lincoln, a president who's usually universally, regarded. Okay? Said to ignore the Supreme Court. So what do we do? Right? Nick, can President Lincoln say, I'm going to ignore the Supreme Court? Can President Lincoln say, he was a lawyer. Lincoln was a lawyer. He said, look, I've read the Constitution. This is wrong. Can the president do that?
I guess if you wanted to somehow overturn those, maybe want to, then have to go through the branch.
Gang up. What do you mean gang up?
Use, ask Congress to help him pass the law.
What kind of law would you need to pass to get rid of Dred Scott? Could a statute do it? You learned this in Marbury.
Makes it even feel the population, right? So
Whoa. So, what's the Emancipation Proclamation? I'm about to blow your mind.
well, it's not a law, right? It's just a directive.
It's an executive order. So what did the Emancipation Proclamation do? Only because you raised it. That's to blow your mind.
I want to say free slaves, but that seems like a pretty
Not all slaves. Didn't free all slaves. This may surprise you, but a lot of the northern states had slavery. Maryland, Kentucky, among others, had slavery. No. Anyone know?
all the slaves in the Confederate States.
All the slaves in the rebel territory. Now, do you know the basis on which Lincoln had to free the slaves?
They were enemy property.
Oh, good. What do you mean they were enemy property?
The Confederate States was considered at war with the so Lincoln felt that he could confiscate the property.
Yeah. So here's what I only bring it up because you mentioned it. In Dred Scott, Roger Taney held that the Africans were property, chattel, right? Same way you'd have like a you know, tractor or whatever, right? Lincoln said, okay, if the slaves are property, I'm seizing them as property. The same way a captor can seize, you know, if an army marches on a farm, they can take the animals and eat them. Lincoln said, I'm going to seize this property. And then once he had the property, he emancipated them, he freed them. So effectively, the Emancipation Proclamation was premised on Dred Scott, that the slaves were property, which could be then freed, the same way you would emancipate a cattle. It's not what you're taught in history books. That's actually the legal basis. And I'll go one more. Does anyone know what happens when you seize government, when the government seizes your property? What must the government do? When the government takes your property, what must you do?
Compensate you?
Compensation. Under the Fifth Amendment, the Takings Clause. Right? Here, go to your constitutions, whip it out. Fifth Amendment, it's on page 44. It says, keep these ready, right? Nor shall private property be taken for public use without just compensation. Slaveholders actually argued that they were due just compensation for the seizure of their slaves because of taking of property. Blow your mind even more. The 14th Amendment, I am not making this up, actually says that no compensation is due for the seizure of slaves. The 14th Amendment, which guarantees equal protection due process, also says we will not have to pay for the seizure of slaves. So only because you mentioned the Emancipation Proclamation, I have to go there. But let's go back to the first decision. Okay, let's go back to the first decision. Is that William? William, can Lincoln just ignore the courts? Why not? Whoa, where's the Supreme Court's the law of the land? Where does it say that? I'm sorry? Where is it the Supreme Court in that paragraph? Nowhere. So let me ask you a question again, William. Where does it say that the president must comply with Supreme Court law? Why can't Lincoln just say, you know what, this is wrong, we're not going to follow it. We are going to prohibit slavery in the territories. In fact, that's what Dred Scott was about. Dred Scott was about whether slavery would be extended to the new territories out west. Lincoln said, screw it, no slavery in the territories. Why can't Lincoln do that? Where? What checking? What's binding him? What do you think, Sean? What's stopping Lincoln from saying to the Supreme Court, screw off, you're wrong. Blacks are not property, they're people too, and we can't have a constitutional right to slavery.
I think it's because each branch is equally powerful, so you can't just.
Well, the Supreme Court made its decision and Lincoln made his. Why does the Supreme Court have a monopoly in interpreting the Constitution? Where do we get that from?
Well, I would say it's because it's their job.
Says
As
so.
the highest court in the United States.
Who says it's their job? Where? Stop. The third person said today. Where in the Constitution does it say that? The answer is it doesn't. We'll read Marbury and go through this in detail, but it does not say anywhere in the Constitution that the Supreme Court has a final say in issues of constitutional law. It says it nowhere. There's a creation of the Supreme Court. It says nothing about that. So generally speaking, when I do this discussion, most people are, either ambivalent or meh, whatever, at Lincoln ignoring the Supreme Court. And I think the reason why is that people, for the most part, agree that Dred Scott was a bad decision, and that Lincoln perhaps was justified in disregarding a decision that was quite awful. And we'll read it later this semester. It's an awful decision to read. It's jarring in some of the arguments Tawney makes, but people are okay with that, saying, yeah, Lincoln, whatever. We can ignore it. I mean, is anyone really troubled by what Lincoln did? The fact that he allowed slavery in the territories? Yeah. What's your name? Scott, are you really troubled by what Lincoln did?
I'm troubled by the precedent he might set. Like, just realize that I don't have to look at the Supreme Court the same way Jackson did. That's their decision. Let them enforce it.
Right. So he never actually said that. So there's this apocryphal story. It didn't actually happen, but it's a good allegory, where the Supreme Court made a ruling, and then Andrew Jackson said, the Supreme Court made its ruling, now let go enforce it. That never happened, because the decision they're talking about didn't actually involve the federal government, involved the state of Georgia. But it's a good story, because saying, who are the Supreme Court? Now, is anyone else really troubled by this? Okay. I mean, for the most part, people either ambivalent, like, all right, whatever, no big deal. Lincoln probably was right, and in the 14th Amendment, they ultimately reversed it. Okay. So the question becomes then, what happens when the people ignoring the Supreme Court do stuff that you don't like, you don't agree with as a matter of policy? One of the things I'm going to try to teach you in this class is to separate policy from the Constitution. If you support Lincoln ignoring the Supreme Court, what happens when other people ignore the Supreme Court? Perhaps involving desegregation, or same-sex marriage, right? Once you set the precedent, right, that you can decide for yourself what the Constitution means, there are consequences to that decision. So please, in your notes, turn to the case of Cooper v. Aaron. It's all the way at the end, page 163. It's a short blurb, but I want you to think about this case closely. Anyone here from Little Rock? Anyone from Arkansas? No one. Anyone from Alabama? Okay, thank you. Roll Tide, right? Roll Tide, or Auburn fan too soon, or okay. That offside kick was insane. Oh no, the onside kick was insane. So in Little Rock, there's a high school called Central High School. It's actually still there. Anyone ever know about this high school? Yeah, it's still there. Actually, I went there about a year ago. I took these pictures. It's the only national park in the United States that's an active school. I mean, there's still kids going there. It's a humongous high school. Okay. The reason why this is a national park is because of this. And let me explain the history of this story. So in 1955, the Supreme Court issued its decision in a case called Brown versus Board of Education. This is one of like 3 decisions people know. They're like Roe v. Wade, Marbury, and Brown. It's the only decisions people actually know outside of law school. Now, we'll study Brown in detail. Brown did not do what you think it did. Brown did not overturn Plessy versus Ferguson. It didn't. Brown did not say that separate was not equal. It didn't do that. It was actually far more narrow. All it said was that in primary school education, the state did not have a sufficient interest to have segregated education. More to the point, the court did not say, effective tomorrow, every segregated school in the United States must shut down and integrate. It did not say that. What the Supreme Court said was schools must integrate with, quote, all deliberate speed. All deliberate speed. What does that mean? Let the lower courts figure this out. So subsequent to Brown, lower courts, the district courts and the circuit courts, began supervising, literally one district at a time, to see how they were integrating. There was massive rebellion to this decision in ways which 50 years later, I don't think people can appreciate. There were school districts in Virginia that rather than integrate, they just shut down their public schools. You have an entire generation of public school students who just had no school. Instead, the city offered these tax credits to go to a private school that was segregated. Or the kids didn't go to school at all. In other places, schools just shut down, period. You have a lot of people who never got their diplomas because the school was closed. One school in particular, Central High School, which was about a mile from the capital in Little Rock, Arkansas, a court issued an order telling the school that they must desegregate. And the governor of Arkansas, a guy named Orville Faubus, said, no. Like Lincoln before him, Faubus said, the Supreme Court's wrong. They are not the only ones who can interpret the Constitution. So can I. I will not desegregate the school. And if you can read this headline, it says, guns force integration. There were similar events in Alabama. Governor George Wallace, Roll Tide, right? At the University of Alabama, he stood in the door frame of the building to block the admission of black students. So this is the question I asked Catherine 20 minutes ago, right? The judge said to Governor Faubus, integrate your schools. He said, no, I will not. So is that John or Cash?
Oh, yeah.
Cash. So what happens when Governor Faubus says to these judges, screw off, I'm not going to do it? Oh, really? The people in effect, right? These people shouting at the black students trying to enter the school, think that they're going to be very upset about this? Yeah, this right there. Are the people of Arkansas going to be very, proactive about this? About trying to, impeach the governor? No. So what happens, Cash? Right. So what are the black students going to do? They sued, right? They sued, and the judge said, integrate the schools. The governor said, screw off, I'm not going to do it. Okay, and then next court says integrate, and they don't do it. Then what? And it went to the Supreme Court. And that's the case of Cooper v. Aaron. And what Cooper v. Aaron basically said, right, is that we are the supreme law of the land. If you actually read the decision, it's not very long. There's not much reasoning there. But basically the court says, we are the supreme law of the land. And what we say is supreme. Now, I've told you this 18 times. That's not in the Constitution, but you know the court said that, and you know they can say that for themselves. So is that Alexa? All right, so it goes to the Supreme Court. The Supreme Court issues a decision, Cooper v. Aaron. Problem solved, right? Go integrate the schools. Let those people go, right? Governor Faubus says, not going to do it. Not going to do it. Then what happens? Then what happens? Who's they? What can the Supreme Justice, what are the justices going to do here? They made a ruling, and then the governor said, screw it, not going to do it. What can the executive branch do to force a governor to do something? What, like a coup? Are they going to shoot him? It's like Latin America, we're going to have a junta? What can they do? Morgan, what can be done after the governor of Alabama says to the Supreme Court, screw it, not going to do it? What can be done? What can be done? What happened here? The courts ruled. The courts already said this segregated school violates the 14th Amendment. They issue the decision. It's printed, published. No doubt. The governor says, I don't care. What can be done? Is that Christine? What can be done, Christine? What happens when people start disobeying the courts? Who's they? Stop using they. Be specific. Which government? The state governor Alabama or state governor Arkansas, they're supporting Faubus all the way. The state government supports Faubus. They're not going to do anything. Delaram? What happens? Who's higher? Why is the executive branch higher? Why does President Eisenhower have more of a claim to interpreting the Constitution than Governor Orval Faubus? Why does the President of the United States have any better claim to interpreting the Constitution than the Governor of Arkansas? Alarm? What do you think, Sydney? Does the president have any better assertion about what the Constitution means than the governor of a state? Why not? No, you're right. I think you're right, but why not? Well, of different levels. The president's the executive branch of the federal government, and the governor is the executive branch of the state government, right? Well, the Constitution says nothing about the state governments and how they're structured, but the states exist. Is that Michelle? Michelle, if you're President Eisenhower, right? We like Ike, right? You're President Eisenhower, and you see that the governor of Arkansas is openly ignoring federal court orders. What do you do? And by the way, Eisenhower did not support desegregation. This is a common myth. He actually didn't really care much about desegregation. But put that aside for the moment, right? You see that the states are flouting the federal courts. You're President Eisenhower. What do you do? Call the military. What are you going to do? What do you mean call the military? We're going to have start shooting at Arkansas people? Like hogs? Make them enforce the law. What do you think? Roll Tide. What do you think? What's your name? Randall. Sorry, too much football today. Randall, what do you think?
I agree.
What? So the executive. You're not know what that is. The executive branch rolls in the tanks down the streets of Little Rock. Men armed with guns seize the state school. Is that what happened? Is that what you do?
I think it's a symbolic gesture.
A symbolic gesture, men with guns.
Yeah, absolutely.
Wasn't that something like the Civil War? Sending federal troops into the state?
Sure. I mean, it's an exertion of power. You're showing that you are superior to the governor of the state, and you have more power at your disposal. And
Yeah.
it's-
Yeah. Is that Felipe or Angela?
well,
Or you guys flip? Just fix on my chart later. Angela, is that what you do? Would you send in federal troops to occupy the school, force them to desegregate, or to force them to integrate? Where do you get the authority to do that? I'm dwelling on this point for a long time for a reason, don't worry. I need you to think this issue through. So I'm calling on about 9 people for it, the entire row across. So what actually happened is just that President Eisenhower mobilized the 101st Airborne to basically drop into Arkansas to assist the students who were called the Little Rock Nine. This is an iconic photograph. To enter the school. Here, I'll show you the pictures in order. These were some of the students, these high school students, Little Rock Nine. They have men with rifles walking them into the building. They're armed because there was a riot mob outside. And you can imagine on your first day of school needing federal troops to walk you into the building, because if they were not there, they may have been lynched. The story goes that after they went to the building, they spent the entire day hiding in the principal's office because they weren't safe in any classrooms. If you ever go there, there's a museum across the street, and it's it's interesting to see for yourself. And this picture is very powerful because you can just see the screaming of the people on the street. And afterwards, you have the governor of Arkansas holding up this newspaper saying that guns force integration. And that's really not much of a stretch, right? Federal troops armed with rifles stormed a school and escorted the students into the building. And there's a letter from Eisenhower. I think I may have actually put it here. There's basically a letter from Eisenhower. And I'll read you this. It's very hard to read. Eisenhower sent this letter to the governor of Arkansas. It's a telegram. Eisenhower wrote, "When I became president, I took an oath to support and defend the Constitution of the United States. The only assurance I can give you is that the federal Constitution will be held by me by every legal means at my command." We like Ike, right? So Ike was basically saying, listen, maybe you can interpret the Constitution however you want. That's nice, but I have guns. I mean, that's it, right? You're welcome to be a constitutional scholar of the First Order of Arkansas, but I have guns. But I am sure we'll give full cooperation to the court. So imagine a different scenario, right? That's Felipe, right? Just come up afterwards and flip the chart. Felipe, or change these, I don't really care. Later, you can do later. So, Felipe, what happens if Eisenhower wasn't in office? Let's say, George Wallace, who was a known segregationist, was in office. He ran for president around that time. Let's say George Wallace was president. And the Supreme Court ordered the school to integrate. George Wallace said, "Pfft." And the governor of Arkansas ignored him, and the governor of South Carolina ignored, and the governor of Virginia ignored it, and the governor of, up and down. By the way, there was segregation like in Delaware and Maryland. People think it's all the South. One of the cases involved in Brown was actually a school in Delaware, so don't think this was a northern idea. Governor of Delaware ignores it. What happens then? Yeah. Yeah, it's a big problem. Why? You gotta be more specific than that. Yeah, give me more than The president says, whatever, I don't care. I agree with Arkansas. I'm not gonna send the troops. What happens then? Yeah, give me something. Go ahead. Impeach who? How does that change what the governor does? They can't impeach the governor of the state.
But the president can do something about the government.
Good. So you impeach the president, the vice president agrees. He says segregation is also. You impeach him also?
Yeah.
And then the Speaker of the House agrees also. You impeach him as well? Daniel, what do you think? What happens if President George Wallace decides not to send the federal troops?
I mean, it's kind of going back to Thomas Hobbes talking about in order for a government to function, you have to have the monopoly on violence, right? So really it is kind of about where can you direct your guns if necessary in order to make any of this even.
And if the president says, I won't even pull the guns out, what happens then?
Then, I mean, the entire Brown versus Board of Education is working about that much.
And then what? Beyond Brown. Beyond Brown, what's the significance if every state starts ignoring the Supreme Court?
It's not going to be enforced.
And then what? Keep going. Well, what's the implication of the states ignoring the Supreme Court and the decision of the court being ignored?
We kind of get complete autonomy from the laws and kind of a general chaos. You're almost going back to like the Civil War.
I think the first sentence of the school was chaos, right? The first class. Is that Cody?
Cody's gone. Charles.
Cody's gone. Ooh. Is he okay? Is Cody still with us? That was morbid. That was Charles. What do we do if people start ignoring courts and all the states start ignoring courts? What does that mean for our republic?
We just into chaos. You have to start using the police. The states will probably start having more control.
So this experiment, which takes roughly an hour, I'm glad you guys cooperated with me on this, is meant to convey a very important point to you. Our republic is very precarious. Our government hangs very gently. It's as if there's a sword hanging over a constitution suspended by a single thread, right? And at any second, if that thread snaps, chaos, Thomas Hobbes, state of nature, we decay very quickly. So the story of constitutional law is really the story of how at many junctures in our history, we've come very close to that cliff. We've stepped onto the cliff. We've looked over the side. And one way or another, at least in hindsight, we went no further. Or maybe the cliff moved. Or maybe someone had a parachute, right? But the story of our republic is that for whatever reason, reasons that I can't even begin to explain to you, our Constitution has endured for 200 years. Right? This little book is the longest serving document in the entire world that's still an active government. It survived Civil War, slavery, Reconstruction, desegregation, and many other battles which we'll discuss at length during this class. Why did it survive? I can't tell you why. What I will tell you is at every juncture, someone made a decision one way or another that said, you know what, I could do something or I could do something else. I'm going to do what I think will save the Constitution and the Republic. So whether it's Lincoln ignoring Dred Scott, saying, you know what, I'm not going to do it. Even if it causes a civil war and the nation's torn asunder, I'm going to fight for it. Or it's President Eisenhower sending in federal troops to occupy a state school. That's a big deal. I mean, that's basically an act of war. I mean, it looked awesome, the pictures of the federal troops escorting the students in, but that's a serious act of aggression, right? A generation earlier, that would have spurred another civil war. But we'll discuss a lot of these, flash points, these inflection points where, remember those choose your adventure books when we were growing up, right? If you take a different fork, a different path, our country looks a lot different. A lot different. And perhaps the first such significant fork in our republic involves the case of Marbury versus Madison. And the tension in that case between President Jefferson and Chief Justice John Marshall in many respects defined the course of how our Supreme Court would maintain that thread by which the sword hangs to this day. So any questions on Cooper? Any questions on Cooper v. Aaron and that nice hour-long? I know it takes a while, but eventually it gets it out of you. Any questions on Cooper? Okay. So let's move on to Marbury. So first, I want to dispel the rumors. You were taught, no doubt, in elementary school and middle school that Marbury versus Madison created judicial review. How many of you were taught that? You're all wrong. All wrong. It's horribly wrong. I love lecturing in high schools to correct them on this horrible misconception. It's simply not true. Right? It's simply not true. And perhaps the easiest way is if you read Federalist 78, which we'll get to in a minute. Hamilton talks about it before Marbury. The idea that British courts could set aside laws that were contrary to acts of Parliament. I'm sorry. The idea that British courts could set aside laws that were violating of the British law. England has no constitution. They have no written constitution. That is an unwritten constitution, complicated. But very often, British courts would set aside laws. Okay, they did it all the time. This was a known feature in the American state courts while there were colonies, and there was no surprise when Marbury happened that courts could invalidate laws. The Supreme Court even considered laws before. What Marbury is the first, though, was an actual act of declaring a law unconstitutional, right? The idea that courts could declare a law unconstitutional, that was very clearly defined. But of actually doing it, that is a different story. Okay, so I want to begin our study of Marbury with the study of two of the Federalist Papers. So again, I assume you don't know any American history, so I'll explain the background. The Constitution was drafted in Philadelphia in the summer of 1787. And as I discussed with you in the last class, after the Constitution was drafted, it then went to the states, who would hold ratifying conventions where delegates would vote. And the Constitution needed 9 out of 13 of the states to approve the charter to move forward. Ratification was no sure bet. In fact, there was a lot of opposition. Some people liked the Articles of Confederation. Others were afraid this new central power, this federal government, would be like the king, would be like a monarch. So it was actually a marketing campaign. A marketing campaign by opponents and supporters of the new Constitution. The leading marketing campaign was a series of essays known as the Federalist, or the Federalist Papers. They were authored by James Madison of Virginia, John Jay of New York, and Alexander Hamilton of New York. They originally set out to write about 20 papers. In the end, I think they had nearly 80 something. The bulk of which were written by Hamilton. Jay only wrote a handful at the beginning. I think he became ill and pettered out. So why do we read the Federalist Papers? Why am I making you read this old stuff that doesn't really make sense? These are perhaps the most developed articulation of the theory of American government that we have. So on the one hand, these were marketing pieces, right? They were trying to sell the Constitution. So you know the difference between writing, an objective analysis and writing a brief? You're trying to argue something. But they still give us such insights into the thinking at the time of the founding of the Constitution that their study is of such deep value and insight. So the first Federalist I assigned to you is number 51. In fact, it's one of my favorites. I do favorites, but this is one of my favorites. And the goal of Federalist 51 is to describe the separation of powers. Where the heck was I up to? I lost count. You? What's your name? Daniela. Daniela, why does our Constitution, at least according to Madison in Federalist 51, why does our Constitution separate powers into the branches, the executive, the legislative, and the judicial? What is the purpose of separating powers in that fashion?
So that not one branch has more power than the others. Keep them track through.
Why? Why not? We had a king. The king had lots of powers. What's the problem with that?
Because when another king could become too powerful and do things that do anything that he would want to do.
Mm-hmm.
And so they didn't want that.
Well, why do we need though, right? What's your name?
Amber?
Amber. But why do we need separate powers, right? Why can't we simply just write a constitution and say, okay, we'll have one king, but the king can only do X, Y, and Z. And you know what? We'll just write this document. King can do X, Y, and Z, and if it's not in the document, king can't do it. Why do we actually need these other branches? Why can't we just limit the king's action by a constitution?
Resist the abuse from the king.
What do you mean abuse? But the Constitution says, king, you can do X, Y, and Z, but that's it.
Well,
What's the
then
problem?
The king would have, they could have motives that would maybe push them in another way that might not be constitutional.
Are you telling me the king may ignore the Constitution? They may disregard what's written?
Yes.
Why would he do that?
For his own benefit.
His own benefit. Right? What's your answer?
Caleb.
Caleb, what is the basic human nature? What is it at bottom that people generally try to do? Benefit themselves, right? I don't say this too callously, but everyone in this room suffers from that, right? It's true. You're all in law school, right? You are working your butts off to try and get an education, to improve your well-being, to improve your life, to help others. I don't care. Whatever your reason is, right? You're all here. You're not at home watching TV. You're all suffering through law school. It's a burden. I'm the first to admit it. But you're doing it because you're trying to better yourself. We are all rationally self-interested. We are all selfish in our own ways. We're trying to improve our own stations. Fine. But the insight from Federalist 51, is there's not necessarily anything wrong with being selfish, right? It's part of human nature. We can't stop a king who wants to grab power. We can't stop a judge who wants to grab too much power. We can't stop a governor who wants to grab too much power, right? Putting paper, what are called parchment barriers, right? Writing in a piece of paper what the king can or cannot do is worthless because people have this ambition, right? People have this ambition to try to acquire more power. So Dylan, what is Madison's insight in Federalist 51? What is the only way to stop ambition? What's the only way?
He says that the constant aim is to divide and arrange the civil officers in such a manner that each may be a check on the other.
Ah.
Private interests, every individual
Good. Now, in your own words, what does that mean?
Huh?
In your own words, what does that mean? Whenever you read, I'm going to repeat in your own words, so don't read.
That's understandable.
Yeah, I know. That's right. When your own words, explain what that means, and don't read it back to me.
So, like, there's a separation of powers to counteract the ambition.
Ah.
We need to have those checks and balances.
Right. So you have Caleb, right, and then you have Dylan, right, and Caleb's the president, right, and he's really ambitious, right, and he's going to get all the power, and then Dylan, you're a judge, right, or you're a member of Congress, and you're also really ambitious, right. What happens when Caleb tries to grab more power? What are you going to do?
Well, I guess I would have to, there would be a case that I would be hearing.
And if you're an ambitious guy too, what are you going to do if Caleb tries to grab power?
I'm going to decide in my favor.
You're going to push back. So he grabs, you grab. He grabs, you grab, right? When you separate the powers, everyone is always fighting each other for power. Everyone's always struggling and clawing and making assertions for power, right? So Colby, what happens when everyone's fighting for power? Everyone's struggling and clawing and knocking out, right? What is the end product of that?
That's would be a balance of power.
Yes. Yes. Exactly. This is Madison's insight. You cannot limit power by paper. Writing a constitution, parchment barrier, so to speak, cannot limit power. The only way to check ambition is with ambition. By taking advantage of how this person wants power and that person wants power, if they fight each other to the death, only the best stuff will make it through. That is a structure of our government. By dividing powers, you ensure that only those with the most support can prevail. Because if someone with not a lot of support tries to push through, he'll get pushed back. Only those with the most claws can succeed. And that is the insight of Federalist 51. Madison writes, ambition must be made to counteract ambition. Ambition must be made to counteract ambition. Take advantage of people's selfishness and self-aggrandizement and use that to impair others. So if the president becomes too assertive, Congress will push back because they want to be assertive. If Congress becomes too assertive, the court will push back because they want to be assertive. Everyone's selfish, get over it, deal with it, and take advantage of it. And it's on this basis that our Constitution turns human nature into a check unto itself. Madison writes, it's one of the most famous quotes in American history. If men were angels, no government would be necessary. If men were angels, look, if we were angels, right? We're angelic. We wouldn't need no government. We wouldn't need no laws because we all know how to behave. But we're not angels. We're little devils, right? The little on the shoulder, the angel and the devil. We're all devils, right? If angels were to govern man, neither external nor internal controls would be necessary. But we are not angels. So Madison says, here's the difficulty in framing a government where we're not angels. We are men over men. You first have to make sure the government can control the people, right? The government needs the power to control the people. But something must control the government itself. And what controls the government itself? Not the Constitution, not the Bill of Rights, other ambition, right? Going all the way around. People don't obey the Constitution because it's a Constitution. People don't obey the Supreme Court because they have a nice building, right? It's the checking of powers that pushes people in the right direction to perhaps, generally speaking, obey the Supreme Court. It's not paper, right? I love this document. I read it, very often. If people stopped checking each other, this would be, nothing, worthless. An example that's often given discusses the separation of powers in terms of third world dictatorships. So if you've ever read the Constitution of the Soviet Union, for example. Have you ever read the Constitution of various, third world dictatorships, junta, whatever, right? They have these beautiful constitutions, all these rights to housing and education and food. But the strongman dictator does whatever he wants because nothing's there to check him. The genius of our structure, as we discussed last class, is the checks. How does a bill become a law? A majority of the House of Representatives elected by the people has to agree. A majority of the Senate, which were originally elected by the state legislatures, has to agree. The president, elected by the Electoral College in all 50 states, has to agree. And that's to get past the courts, who are appointed by the president, confirmed by the Senate for life. There are so many points at which the process can be held up. So many points. Indeed, in parliamentary systems, like in England, it's a lot easier to pass laws, right? Our system is not meant to make it easy to pass laws. In fact, gridlock is a feature of our Constitution, not a bug. So here we have it, right? Ambition must be made to check ambition. Every branch is accountable to the other branches. You'll notice in Federalist number 10, right? You'll notice in Federalist number 10, I'm sorry, 50, I keep saying 10, we'll do 10 in a few weeks. Federalist number 51, Madison doesn't really mention the courts at all. He mentions nothing about the courts are involved in separation of powers. That was not an accident. Okay, Federalist 78 is what moves on to the courts. All right, so any questions on 51? Any questions on 51? I keep saying 10 because 10 is my other favorite one for Madison. I always get them, I always mix them up, but they're both awesome. So let's move on to Federalist number 78 by Alexander Hamilton. And this is probably the most famous pronouncement of the judicial power ever. And as you were reading Marbury, you should have been saying, oh, wait a minute, Hamilton said that. Oh, no, wait a minute, Hamilton said that, right? Hamilton and Jefferson, I'm sorry, Hamilton and Marshall were very similar thinkers in terms of the structure of the government. And very often, whenever Marshall writes something, it came from Hamilton. Okay? Well, at this point, Hamilton was already dead by a duel, or soon. No, he wasn't dead quite yet, but he was soon to be dead. All right, so what was I up to? You, Elizabeth? Okay. Elizabeth, how did Hamilton see the judiciary? What did Hamilton envision the role of the courts to be? I'm sorry, say it again? They were weak. What do you mean they were weak? Ah, yes. So the exact discussion we're having, Hamilton understood 200 years ago, right? Really, I could have just skipped this class and to go read Federal 78 because everything I said today was in Federal 78. I read it every semester. I was like, wow, he was on top of his game. Hamilton, I mean, if you ever have a chance to go to Broadway, there's a new show called Hamilton. It's remarkable. I saw it a few weeks ago, but it's based on a book by Rod Chernow called Alexander Hamilton. Hamilton was basically born as a bastard child in the Caribbean in St. Kitts. Unclear who his father was. And he was developed as a prodigy at a young age. And the people in his town recognized how genius he was. They actually took up a collection to send him to America to study. And he arrived, I think, in 1774, 75, right on the eve of Revolution. And the story is he tried to go to Princeton, then called the College of New Jersey, and he said, I want to graduate in 2 years. And they said, what, are you crazy? You can't do that. He's like, I want to graduate in 2 years. And he actually punched out the registrar or something like that. He was very choleric, very, very hot under the collar. But then at the dawn of the Revolution, he became General Washington's aide de camp, basically like an advisor, a junior advisor. And he was right there with Washington the entire time. He became Washington's dear ally. And he was a brilliant man who would write so much. And during the Constitutional Convention, he was a very instrumental player in getting the thing ratified. He wrote most of the Federalist. His mind was on a different level. He, as the first Secretary of the Treasury, he basically created our system of credit. Credit was not a quantity that was known. We basically built our entire economic system. The last time the United States balanced a budget was Alexander Hamilton. This is the last time we had no deficit. He managed to pull that off. A remarkable individual, also crazy. He was such a manic obsession with honor that he stupidly was drawn into a duel with a man named Aaron Burr. And if you can imagine this, Aaron Burr was the vice president of the United States who basically killed Alexander Hamilton and shot him in a duel. It's surreal to think about, but dueling was a fashion of resolving disputes back then. You learn about alternative dispute resolution. Well, dueling was a form of ADR. It's true. And in fact, a funny aside on dueling, the Kentucky Constitution actually says that you cannot be an officer of the state if you've ever fought in a duel. So recently the governor swore his oath, and he had to say, yes, I've never fought in a duel. And if you want to be a lawyer in Kentucky, take the oath for the bar, you have to say they've never fought in a duel. So that's still around today. So back to Hamilton in Federalist 78. Hamilton explains in a great detail that the courts are, as Elizabeth said, the least dangerous branch. That's his phrase, right? This is the money quote that's been quoted a million times. The courts are the least dangerous branch. Why are the courts the least dangerous branch? Because they have neither force nor will, merely judgment. The courts have neither force nor will, merely judgment. What does that mean? Congress has the power of the purse, right? Nicole, what's this power of the purse business?
I mean, they have the will that I guess the judiciary doesn't have.
What's the power of the purse? What does that mean? What's a purse? What power does Congress have? What does that mean, the power of the purse?
Create laws.
What comes out of a purse? What does Congress do?
Say where money goes.
Spend, yes. Congress has the power to spend money. If the president wants to hire an army, that's nice. The president has no money for himself. If he wants to pay salaries for his soldiers, that's nice. Congress makes all the appropriations. So Congress has the power of the purse. If Congress decides not to fund something, no matter how much the executive wants it, it won't happen. Did I do this right? I can't remember. Did I do you guys last time? You? Yes, sir. What's your name? Zach. So the Congress has the power of the purse. The executive is said to have the power of the sword. What does this mean, the power of the sword?
Power of the sword. They have the power to, well, we said it before, basically, Congress has the power of the purse to pay for it. The power of the sword would be to say what the military armed forces are going to do. To pay them.
Right. So the courts, so the Congress has its power of the purse. They fund stuff. The president has the power of the sword. They do stuff. Helen, what power do the courts have? This is the question we're discussing all day long. What in Hamilton? What power does the courts have?
Well, it says they secure study of writing commercial administration.
In your own words, don't read.
Okay.
Note the rest of the class. Don't ever read, especially when it's complicated Old English.
Sure. Okay. Well, you said that they pass judgment, so they
Yeah, that's right. They have neither force nor will. They can't force people to do something. They can't pay them to do something. All they can do is issue their judgment and hope people comply. Right? This is a remarkable concession because today we think of the Supreme Court as probably the most powerful body in the world. Gay marriage? Sure, why not? Guns? Sure, go for it, right? Affirmative action? No, can't have that, right? We think of these judges as, demigods, right? That they have such authority. But Hamilton is saying, look, they're not going to be that dangerous, right? They have no power. They can't do much. They're the weakest of the three departments. They can never attack the other two. But why are they necessary, Clayton? Why are the courts necessary?
Because they kind of police what the other people are doing.
What do you mean police?
Like they almost almost take on a protective role. So while the legislature and the executive can be more aggressive,
What do you mean? I don't want you to be more aggressive.
like they can control like the person's sword. So judicial's kind of like the referee.
Yeah, but we know the judges, they're appointed for life, right? The president nominates them, the Senate confirms them. They're appointed for life. The salary can be decreased, right? Let's see, is that Kaysen? Kaysen, how do we prevent judges from going rogue? They're independent, right? They never have to be reelected. They get their guaranteed salary. What if a judge is ambitious? He wants to, get all the power for himself. What stops that?
Well, they're still checked by the other branches.
How? What is the check that the other branches have on the courts? They have life tenure and they have guaranteed salary. How do the other branches check the courts?
Well, the legislature can still sort of regulate the court.
How?
They decide their jurisdiction.
Ooh, good. So we'll get to that in Marbury, right? But more meta, beyond just jurisdiction, right? How does the other branches check the courts? You're exactly right about jurisdiction. We'll get to it with Marbury. You're 100% right, but I want to get something else. Emma?
Yeah.
Okay, just make sure you write your name on the thing afterwards, okay? Emma. So what? How do the other branches check the courts according to Hamilton? Good behavior. So impeachment. That's right. Basically, the only remedy for a rogue judge is for impeachment, which means that half of the House of Representatives and 2/3 of the Senate must vote to remove the judge. That's happened maybe a dozen times in 200 years. Not many times. I can Google it, but I mean, it's a fairly small number. Although I will note that after Brown v. Board of Education, throughout the South, billboards popped up saying impeach Chief Justice Earl Warren. Well, that impeachment would not have gone anywhere. But at bottom, right, Hamilton says we need courts to interpret the law fairly, because if there's a conflict between one statute and another, the courts are uniquely suited. By the way, there were state courts, right? We're only talking about the federal judiciary. There were existing state courts. They've been in existence for 100 years. Hamilton also said the courts may substitute their own pleasure for the interest of the legislature. What if the courts do what they want, not what's in the public interest? Hamilton says, well, the best way to present that is to be giving them life tenure, and they won't be worried about popular opinion. If we insulate the judges, we protect them from public opinion, they won't have the ambition to try to take over. It's unclear if the insights that Hamilton worried about would pan out. Because in many respects, if you ask people today, the court perhaps is the most dangerous branch. I think Congress is, but it's all there. Any questions on Federal 78? Questions on Federal 78? Okay. Let's move on. At long last, the thing you read first. Like, when are you getting to it already? I promise I'll get to it. Marbury versus Madison, all right? The famous case that everyone thinks established judicial review, but did not. So the facts of Marbury are amazing. If you actually had made a movie about this, people wouldn't believe it, but it actually happened this way. So our first president was George Washington, right? And he served for 2 terms. And many people expected Washington, like a king, to serve for life. And he had such popularity, such renown, that he probably could have been reelected forever. But after or during his second term, he decided that he would step down. Washington had this image in his head of a Roman general named Cincinnatus. And Cincinnatus famously was this Roman general who was, retired, and they called him to service to lead a war. He led this war victoriously. And afterwards, rather than becoming a dictator, he went back to his farm. Washington, embraced this image of being the noble general. After the war was over, go back to his farm. Indeed, after the Revolutionary War, he resigned his commission and he went back to his farm in Mount Vernon, Virginia. Then, when the Constitutional Convention happened, he returned to public service. James Madison begged him. He said, fine. So he presided. And then he was basically elected president pretty much unanimously. Everyone agreed. Second time up, it wasn't quite unanimous, but it was close enough to unanimous. But Washington said, 2 terms is enough. I don't need any more terms in office. So the election of 1796 was the first actual presidential election. And as the law worked back then, the person with the most votes became president. The person with the second most votes became vice president. Not a very good system. So you actually had President John Adams, top. Number 2 is President Thomas Jefferson. Adams and Jefferson hated each other. They had this long blood feud that went on for decades. They eventually had a reconciliation, but it was fairly late in their lives. So fast forward to the election of 1800. Okay, Thomas Jefferson wins the presidency. Okay, Vice President's Aaron Burr. He was the one who shot, Hamilton. I mean, it's insane to think about, right? Jefferson was the president. Adams's party was the Federalist Party. Jefferson was a Democratic Republican. Shortly before the Adams administration finished, the Federalists said, wait a minute. Our party is about to lose power for a very long time because their party had been wiped out. There would never be another Federalist president ever. So the Adams and the Federalist Congress said, you know what we're going to do? We're going to put a bunch of Federalists onto the courts with life tenure who'll be there long after we're gone. And one of the first nominations, or one of the most important nominations Adams made, was to the Chief Justice of the United States. Adams nominated a young man who was in his 40s named John Marshall to be the Chief Justice of the United States. Okay. Adams also nominated Marshall to be the Secretary of State. Whoa, right? That'd be like John Roberts and Hillary Clinton being the same person, right? At the time, simultaneously, John Marshall is both the Secretary of State and the Chief Justice. Perfectly constitutional. There's nothing wrong with that. So what happened? In the waning days of the Adams administration, the lame duck Congress passed the Judiciary Act of 1801. And they created all of these new judicial positions, which they stuffed or packed, if you will, with all these Federalist judges. They're trying to basically get their guys in the court, have them there for a long time. Okay? So what has to happen in order for a judge to be appointed? Well, a few things have to happen. The president must nominate them. The Senate must confirm them. Afterwards, the president signs the commission, and then the Secretary of State, puts a stamp on it. They put the seal on it, and then it gets delivered to the judge who assumes his office. Right? That's the normal process. So Adams got all of his judges appointed, nominated by the confirmed by the Senate, and Adams signed all the commissions before he went to sleep. This was the final night in office. He signed them right before he went to sleep. Why did he go to sleep? He hated Jefferson so much, he wanted to get the hell out of town before the inauguration. He did not want to be there. So basically he left at like 4 in the morning or something insane like that, right? So basically he signed these things in the middle of the night. Now, there were no cars back then. There were no ways of getting around. So they had some difficulty, Marshall and others, scrambling to deliver all of these commissions, all these, appointment papers to the people. And for reasons that have been lost to the sands of time, John Marshall was responsible for delivering one commission, that of William Marbury. John Marshall, because he got to it so late, never delivered William Marbury's commission. Never delivered it. Okay. The next day, President Jefferson takes office. The new Republican Congress basically abolishes all these new judgeships. Abolish them. Can you eliminate a judge with lifetime tenure? Well, that's Stuart v. Laird. The answer is not clear. Marbury goes to the Jefferson administration. Hey, wait a minute. You know what? I want to be a judge. I want to be a justice of the peace. Give me my commission. Who is now the Secretary of State? Who's Madison? James Madison. James Madison said to Marbury, screw off. I'm not giving you anything. Basically, Jefferson said, we're going to ignore all of these midnight appointments, these last-minute appointments, right? We're going to ignore these appointments. So what did Marbury do? He did what all of you would do. He sued. And he didn't just sue anywhere. He filed the suit in the Supreme Court. Now, so wait, how do you file something directly in the Supreme Court? Don't you have to file in the lower court, and then you appeal, and this and that? Marbury was going to sue in the Supreme Court to get his commission, to get his appointment. Now, before I get to the facts of the case, the actual politics are fascinating. The suit was filed in 1801, about 9 months after Jefferson took office. What did the Republican Congress do in 1801? Or sorry, 1802? They abolished the Supreme Court's term. By statute, the Congress said, hey, Supreme Court, you guys aren't going to meet. Jefferson had no interest in Marshall stopping anything he was going to do. The case was finally argued in 1803, the following year. Now you imagine, in a case of such constitutional importance, right? Marbury versus Madison, you would think that James Madison would be there to argue what the Constitution means, right? Wouldn't it be awesome if we knew what James Madison thought about the Constitution? No one showed up. Jefferson held the court in such little regard that he didn't even bother sending a lawyer to argue the case. You have James Madison, the father of the Constitution, who didn't even bother going to the court to argue about what the frickin' thing means that he wrote. It's remarkable if you think about it. It really is. So the case was only argued on one side. So if you read the opinion and Marshall says, well, the opinion's at the bar, you know, he's being sarcastic because no one argued the other side. He's being a little bit of a smartass. He's very good like that, right? So the case was decided in 1803. Now, one last point before we get to the facts. Had Marshall ruled against Jefferson, had Marshall said, you are required to give Marbury's commission, Jefferson would have ignored it. He'd already abolished the court's term. He basically started talking about impeaching the Federalist judges. Had Jefferson lost, he would have ignored it. So the starting premise of this decision, and this is why I'm not a fan of John Marshall. The decision's wrong, but we'll get to why it's wrong in a minute. It's wrong on the law. But effectively, his decision could not have been what actually was. He had to rule the way he did. So he started with an outcome and worked his way backwards. I humbly submit this is not a particularly good model for a judge. But the flip side, right? The flip side to this is one of those moments where the sword was hanging by a thread. And had Jefferson lost and been ignored, that would have made the Supreme Court irrelevant. Because in the first, decade of the Republic, the Supreme Court was just brushed aside. So Marshall's goal was to discuss this power of judicial review, but do so in a manner that ultimately Jefferson won. And that was the magic of this case. Okay, one last point before I go into so much good preliminary stuff. Marshall was the person who failed to deliver Marbury's commission. He should have recused. The entire reason this case came up was because Marshall screwed up. There's actually one point in the opinion where he says the commission was not delivered. Well, nice use of passive voice there, Johnny boy, right? He is the reason why the case should never have been heard. He screwed up. This was his fault. It's all his fault. So he should have actually recused. He recused in other cases. He didn't recuse in this one, but I'll stop there. So now, that nice history. Let's actually talk about the case itself. The case itself is actually not that complicated. And Of all the old opinions you read, this one's very well laid out. Actually, very easy. 1, 2, 3, right? It's very easy. The first question is one I'm not very much concerned with, right? Does Marbury have the right to the commission? This question he answers yes. Okay. The reason why he has the right to the commission is because the Constitution gives it to him. The Constitution says the president nominates someone, the Senate votes on it, and then the president signs it, right? Those three things happen. There's a nomination, the Senate votes on it, and then the president signs it. Then there's other business with the seal, which, you know, is just a formality. Does it matter whether the commission was delivered or not? Marshall says no. I think this is probably right. The second the president puts a signature on it, that's it. The act is done. And the example he gives is an easy one. What happens if someone gets a commission and their house burns down or their house is robbed? They lose the piece of paper. Does that suddenly mean they're not a judge anymore? Of course not, right? They can go and write to the Secretary of State and request a duplicate. So, right, that part's easy, and that the court dispatches it very quickly. The much tougher questions are, second, right? Do the laws of this country give him a remedy? And third, can this court, the Supreme Court, give him this remedy? Those are the trickier questions. So the second question is based on what's often called a political question doctrine. Is that Kiara? Kiara, what is the danger? What is the risk when the courts start interfering with who the president appoints to different positions? What's the risk there? Yeah. So generally speaking, should a president have the power to decide who works for him and who doesn't? Why? Why does the president appoint certain people to different positions? What is he trying to get out of it? And how do those people do that? What do those people do for him?
They basically give out his, they have carry his view to like the constituents.
Yeah, they execute them, right? The president's not the one leading charges on battles, right? The president's not the person actually going and handing out passports. The president hires people to help him, to assist him. And one of the core functions of the president is that he gets to decide, you know, who's working for him and then what they're responsible for. So the court says, look, we're not interfering with decisions of who a president appoints. That is what's called a political question. And write this down, it's something called the political question doctrine. There's certain political decisions which are not subject to review by the courts, right? Who the president hires, the court's not going to get involved with that. That's a very important decision that the president needs to make for himself. Under the political question doctrine, the courts will not review or second guess certain decisions the president makes. Everyone get that? Davian, but is this case second guessing or questioning any of the president's judgments? Does this case in any way? Well, is this questioning Thomas Jefferson's judgment in any respect?
No.
Why not?
I mean, because he's just trying to get them to continue, like, finish the power that he should have received from the beginning.
Whose decision to appoint Marbury? Whose decision was it? Who made the decision to appoint Marbury?
Jefferson?
Wasn't Jefferson. Who made the decision to appoint Marbury? From the history? Who came before Jefferson?
Oh, Adams.
Adams.
Sorry.
Adams was decision. Davian, once John Adams put his name on the signature block, what was the effect of signing that piece of paper?
The decision was made
Final. Exactly. Once Adams signed the commission, it was final. It was a done deal. It was done. So an order from the court about this in no way impacts President Jefferson's decisions because he has no power over a commission that's already done. It's not questioning his judgment. It is not a political question because simply stated, Marbury gets what he deserves. He already has a right to this commission. In no way is a court interjecting into politics to decide this. Okay? Everyone see that? So this much is easy, right? This so far so good. I'm with Marshall 100%, right? The second Adams' signature was signed, the position was filled, done. A court can review that decision because it's a matter of right. This is not challenging the judgment of the President Jefferson. Everyone with me so far? If you don't, raise your hand, please. Your hand up? Okay. It's the third question that is the most problematic. It's the third question that is the most problematic. So, one of the most important laws ever enacted, one of the most important laws ever enacted was the Judiciary Act of 1789. This law was passed, I think, within the first month or so of the Congress meeting in 1789. I actually looked this up. In the same week that Congress proposed the first 12 amendments to the Constitution, they signed this into law. So I've got priorities, right? They signed this into law, and then they proposed the amendments to the Constitution to give you a sense of priority. The Judiciary Act of 1789 had the effect of creating our federal court system. You'll recall here, everyone please open your constitutions, Article 3, Section 2. We'll be looking at this a lot. Let's get the page, just call that. Article 3, Section 2. It's on page 31, bottom of page 31. I have it up here if you don't have your constitutions, but you all should. Okay. So Section 1 begins. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. So the Constitution only creates one court. It gives Congress the power to create the inferior courts or the lower courts. And the Judiciary Act of 1789 did just that. Okay? But it didn't just create lower courts. It did something else. It said the Judiciary Act of 1789 authorized the Supreme Court to issue writs of mandamus. What the heck is mandamus? Mandamus is basically an order from a court to instruct someone to do something. Mandamus is an order from a court to instruct some official to do something. Okay? Now, that much is easy, right? There's nothing wrong with Congress giving the courts power over mandamus. The problem is it gave the Supreme Court the power to issue mandamus. It gave this power to the Supreme Court. Okay? Here's where it gets tricky. So go down to Article 3, Section 2. Okay? Article 3, Section 2 defines two types of jurisdiction. There's original jurisdiction and appellate jurisdiction. Okay? Now pay close attention, this is a little bit tricky. Appellate jurisdiction means what kind of cases can the Supreme Court hear and appeal? Original jurisdiction refers to cases the court can hear that are filed in the original Supreme Court's jurisdiction. What does that mean? You can file certain cases at the Supreme Court on day number 1, believe it or not. So for example, it says, in all cases affecting ambassadors, whether public ministers or consuls, or a state shall be a party, the Supreme Court has original jurisdiction. So even today, When two states sue each other, when Texas and Oklahoma disagree over the boundary of the Red River, right? They don't go to a trial court. They go right to the Supreme Court. When there are cases involving ambassadors and ministers, right? They can go directly to the Supreme Court. The things that are listed in the Supreme Court's original jurisdiction are limited. You have ambassadors, ministers, and where states should be a party. Does anyone see anything about mandamus? Ooh. Does anyone see anything in the Supreme Court's original jurisdiction saying that the Supreme Court can grant mandamus? Wait a minute, but didn't the jurisdiction, the Judiciary Act of 1789 say that the Supreme Court's original jurisdiction includes mandamus? This is what Marbury sued on, right? He sought mandamus in the Supreme Court's original jurisdiction. But the statute says they have mandamus, and the Constitution says nothing about it. What do we do? What do we do? The statute provides for mandamus in the original jurisdiction. The Constitution says nothing about it. What do we do? What Marshall said was that the Constitution prevails. Marshall held that because the Constitution does not let Congress expand the Supreme Court's original jurisdiction, this provision of the Judiciary Act is unconstitutional. Let me say it again. Marshall held that Congress cannot expand the original jurisdiction of the Supreme Court. They could only do those things that are listed here, those 4 or 5 things. Because mandamus was not among the things listed by the Constitution, Congress could not expand the court's original jurisdiction. Congress could expand the appellate jurisdiction, right? It says here, for appellate jurisdiction, Congress can make regulations, right? So no problem if Marbury had sued in the trial court and then sought an appeal from the Supreme Court. That's fine. But Marbury's error, said the Chief Justice, Marbury's error was suing for mandamus in the original jurisdiction. Because Congress tried to unconstitutionally expand the court's original jurisdiction, this statute must be set aside. Marbury says, Marshall says, a statute that's inconsistent with the Constitution cannot be the law. Boom. Act of Congress invalidated. And not just any act of Congress. This was an act by the very first Congress with James Madison at the helm. The very people who wrote the Constitution wrote the Judiciary Act of 1789. And then Madison decided that it was unconstitutional. Chutzpah, huh, right? Now, I said before, Marshall's almost certainly wrong, and I mean that sincerely. Does it say here anywhere that Congress cannot modify this? Does it say anywhere here that the only things that Congress can do are these 4? No. This is the, if you remember from contracts, the expressio unius canon, right? Right? Well, they listed these 4 things, that must mean everything else is excluded. Who's to say that's the right rule? And in fact, as a matter of history, if you actually look at the debates of the Constitution, Marshall is entirely wrong. There's nothing wrong with the Supreme Court's original jurisdiction to be expanded, right? But such is life. Such is life. So what did Marshall do, right? He said, first, you know what? Marbury became a judge. Second, he's entitled to his commission. But third, sorry, we can't help. We don't have jurisdiction, right? Because our jurisdiction doesn't allow mandamus, buddy, you're out of luck. Go file in another court, which apparently he never actually did. That is Marbury in a nutshell, right? In the process of finding a way to rule in favor of Jefferson, that is, there's no way for us to force Jefferson to give this commission, Marbury established that the courts could invalidate these laws. questions on Marbury? It's a very tricky case, which I tried to condense for you, because the actual legal arguments are not nearly as important as the principles established. Yes, sir.
So the writ of mandamus is pretty much an order for a specific performance, if you will.
Exactly.
If the court were to issue that, how would it enforce it? Would it rely on the executive branch?
Yes, but before I get there, sir, what's your name?
I prefer Dan.
Dan. Okay, just write that on the sheet afterwards, please. Okay, Dan. In order for a court to make a ruling, what must they have? Basic 101. In order for any court to decide a case, what must they have?
Case and law.
Jurisdiction.
Oh, yeah.
A court that lacks jurisdiction is worthless. Dan, if the Supreme Court has no jurisdiction over mandamus, can they grant it?
No.
That's why, oh, where is he? You said before. Yeah, you said before. One way that the Congress can control the courts is by limiting their jurisdiction. So by prohibiting the courts from doing X, by limiting their jurisdiction, you actually do control the courts. Okay? All right. Yes, sir. What's your name? Taylor.
But I understand what you're saying, but wasn't the purpose of the Judiciary Act to give them extended
Yes.
jurisdiction?
So the Judiciary Act tried to give the Supreme Court the power to compel officials to do stuff. And Marshall said, nope, you can't give us that power. What?
It was a trap.
Akbar, right? Yeah, it's a trap, right? Again, the ruling itself is not self-evident. It's not clear from the Constitution that this is right. I think it's probably wrong, if you ask me. But the decision itself isn't as important as what it establishes. All right. Other questions on Marbury? Yeah, go for it.
You said that Marbury versus Madison actually did not establish judicial review.
It did not.
But isn't what they decided in setting up the precedent for judicial review?
It was the first instance where the Supreme Court invalidated an act of Congress.
So how does that differ from?
Because it had been done before in the state courts, it had been done before in the lower courts. The big difference is that for now, the Supreme Court said to Congress, we'll do this. Just because something had been done before, it wasn't clear. I mean, recall, Hamilton said it was the least dangerous branch. And there was a strong sentiment that this court wouldn't really do much, that it would just resolve disputes between states, maybe. But here, the court interjected itself in a serious political dispute and said, we're not going to rule against the president this time, but maybe we will next time. And over the course of the semester, we'll read maybe 5 or 6 Marshall opinions that set strong precedents on the scope of national power in various realms. All right, other questions? All right, have a wonderful day. I will see you on Thursday. And please, if your name is not on here correctly, please fix it. Oh, yeah, just write whatever you want to be called.
I think you're over there. Yeah, so, yeah.
Thanks.
Yep, no worries.
And the attendance sheet, bring back up. Oh, you're exactly right.
I'm really looking forward to having front law as an undergraduate with former JAG director.
Oh, very nice.
So I'm really looking forward to getting one again.
Hope you enjoy it. Yes, sir.
The ruling is not important.
Yeah.